perhaps some introductions then. So me, I'm Bev. I'm only Beverly when I'm in trouble. That's a throwback to my mother, and I'm also known as the data protection lady. I have worked in data protection scarily for about 22, 23 years now. I'm not a lawyer though, I'm a practitioner. But I've worked in the charity sector for 12, 13 of those years until last year. I was the DPO at Crisis UK. I'd been there 5.5 years. I've worked at the NSPCC and I'm supporting a few charities at the moment, either as an outsourced DPO or providing consultancy services to them. Gary, do you just want to introduce yourself? And I have to say, Gary and I have known each other 6 or 7 years now, is it?
Yeah, about that, yes. Yeah, when you were at Crisis. So yeah, about the same sort of timescale, about 20 odd years doing data protection from a local government background initially, and information rights more broadly, records management, that sort of thing. I set up my own company 10 years ago because I realized people didn't need lawyers, they needed practitioners to do GDPR. So yeah, I had great fun learning about how to set up a company, how not to run a company, how to, lots of skills and knowledge, and interesting experience. But I left there about a year ago, and I've been freelancing, consulting ever since, because I still love the topic, still find it interesting and passionate about it. And a bit like Bev, being a bit of a DPO and consulting on all different aspects. And get to do fun things like this with good people, which is lovely.
Great, thank you, Gary. Okay, so we're going to kick off. This is going to be an informal discussion about DPIAs. If you have any questions, because it's a small group, you can raise your hand and ask if you want to, or you can stick them in the chat. So I just want to kick off, kind of, Gary, because what is a DPIA? How would you describe one? Yeah,
they're fascinating, really, because in a nutshell, they're just risk assessment, like you do for anything else with health and safety or in quality and diversity. They're essentially a risk assessment for data protection, which is both a blessing and a curse, because it means our colleagues kind of get it and kind of want to do them, unlike other aspects of data protection where they don't know about it or don't care or don't maybe engaging it. Oh yeah, I've got to assess risk, I need to do an assessment. They kind of get that, and they've become the go-to thing after a lot of the time. You'll find that people want to do or think they've got to do an assessment. However, ironically, to do a proper impact assessment should be quite a rare thing in an organization. What is often confused is assessing whether a project or something we're looking to do is compliant with GDPR. That's one thing. Standing back and doing a formal impact assessment is something quite different, but they often get very conflated in the minds of our colleagues, and conflated often when we engage with the topic.
So when should, sorry, Gary, I was going to say, so when should an organization do one?
Yeah, so the GDPR in its lovely way is reasonably clear, even though it uses a long, convoluted way of describing it. But it's basically saying, well, look, if you're doing new, innovative things that are pushing the boundaries and might result in a high risk to people's rights and freedoms, before you even get going, you should really stand back and think about the implications, and importantly, think about the implications for the people whose data you're going to be handling, not just the implications for your organization. And that's another bit that is often missed, or not quite papered over, but our colleagues might spend so long filling in templates, and we'll come on to templates in a moment, I'm sure, filling in templates around, understanding the journey of the data and looking at lawful basis and doing all this hard work. They get to page 15 of the template, and then it says, oh, and now think about people and the privacy impact and the harms. To me, that's the core point of it. So all these templates are kind of written quite poorly. You've got to get around to some of that stuff, but it's about people. What we are going to do with this data, what could it mean to people? And could it be harmful? Could it be detrimental? Have we not thought through this enough? That's the point of doing the impact assessment.
So you mentioned, Gary, that it should be in cases of high risk processing. What is high risk processing then? When should people be thinking about it?
So again, this is where the legislation, the GDPR, UK GDPR, gives us 3 mandated times when we should do an impact assessment. And for most organizations I've ever worked with, it doesn't apply to them. So systematic monitoring of a publicly accessible space on a large scale. Well, unless you're Google and you're monitoring online platforms, or you're Birmingham City Council and you're putting CCTV across the whole of Birmingham, that's probably not going to, you're not going to be monitoring public spaces. Similarly, you're not going to be processing large scale health data or sensitive data. Large scale is not defined in a legislation, so you can argue it either way. And you're probably not going to be doing the first one, which is systematic and extensive evaluation of people, automated, that could have an impact on them. That's probably quite rare for most organizations as well. If you're a bank and you're bringing in an automated vetting for mortgage applications, maybe that's where you've got to look at the privacy impact. Or you're the government and you're going to change how pupils get their A-level results, and you're going to do an algorithm to judge their A-level results. Well, then you'd want to do a proper impact assessment on that. That's have a serious impact on thousands of children. So the three that are mandated that you see in the legislation don't apply to most organizations. However, there's a little line in there that says the regulator, the ICO, should make its own list up as well of high risk processing. That's the one you want to look at. That's on the ICO's website. And that's where it does capture more organizations, because that's where it's saying, well, okay, there's other things that you might do with data that are getting into being more high risk, such as, profiling data, doing things behind the scenes, combining and analyzing data that people aren't probably aware of, maybe using data on children or vulnerable people to target advertising, using data to make decisions on people that they're not maybe aware of going on behind the scenes. So there's a list of high risk activities that the regulator defines that you want to have a look at. So that's where, there's things there.
Can I raise a perennial chestnut that I've experienced in charities, and you may have done as well, Gary? What about wealth screening?
Yeah, that's a good example of one where, the business has got probably in its head, a very strong desire to want to do wealth profiling, wealth prospecting, whatever it is, to understand who its donors are and what have you. But that is basically analyzing data behind the scenes from a number of different sources, coming up with new understandings of those people, and they don't know what's going on. That's a good example of where you'd need to do an impact assessment. Because what does it mean to do that?
It's what I call the reasonableness test. Would somebody reasonably expect you to do that with their data? They've given you their data for one person. As you say, you're doing something in the background. So what are the benefits to an organisation of doing a DPIA then?
Yeah, well, the benefits of doing it well, it sounds stupid, but doing it early, really understanding what we're trying to achieve from it. The benefits are that you can actually build the project, the plan, the scope, actually define the project with data protection and privacy at its heart. You can basically save time, save money, save resource, rather than having to bolt things on at the end because you forgot to do the sort of data elements of it, or not even deploying them, launching this thing and then it hitting the fan when actually you've done something where you really shouldn't have done it because you didn't assess the impact or think of the implications. So if it's done really well, it's a space to really think through the implications, build out the project plan, the specification of the project or the system you're looking to procure with these data elements in mind. And actually you should, in my mind, you get a list of actions from it. A good DPIA often results in, okay, we were looking to do X, we want to tweak it a bit to make it really privacy friendly, but still achieve our objectives. Here are the 5 recommendations we now want to take into the project and follow them through. That's what a good DPIA should really lead to, in my mind.
So let's talk about how you do one then. I mean, you mentioned someone getting to page 15 of a template, and I'm sure that would put a lot of people off even doing one in the first instance.
Yes, yeah.
So what are the key elements that comprise a DPIA?
Yeah, so this is where, like a lot of aspects of the GDPR, and understandably, back in 2018, 2019, a lot of organizations, a lot of people went to legislation, literally look at what it says and thinks, well, that's how we've got to do it. So in the GDPR, it says the assessment shall contain, and it lists 4 points, A, B, C, D. So people have taken that and gone, right, well, that's the first thing I need to do, a systematic description of what we're planning to do. And then I've got to do necessity and proportionality, and they followed it as if it's telling you how to do it, and it isn't. It's just saying the assessment should get round to these things. How you go about it is up to you. And that's why I think the sort of template approach that's out there often doesn't help our clients, and it gives it a bit of a bad name because people lose the will when they get to page 15. To me, yeah, sorry, Bev.
I was going to say, I've seen a lot of templates in my time as well. Some, as you say, are very, very lengthy. Others are far more pragmatic in their approach and actually guide somebody and say, if you don't do this, you don't need to complete this area. So are there any templates you've seen or that could be recommended to people that they can use or adapt?
Yeah, well, actually, I mean, the thing I would advocate is the screening questions, as in let's cut the wheat from the chaff. When do we actually have to do a proper impact assessment, and when are our colleagues actually just changing supplier? So actually we just need to check the contract's got the right things in it from a data protection compliance point of view. Let's just double check that in changing supplier we're not doing anything different with the data, and if we're not, we don't need to do an impact assessment. We just need to check the contract's right. So a screening process, I think, is a critical thing to this that's often a bit overlooked. Really understanding which are the administrative compliance things that it's good our colleagues are reaching out to us to talk about, but we're not really assessing the privacy impact because we're already processing the data, we're just switching supplier. Well, we can't really stand back and assess the harm because the harm's happening because we're running that contract and doing the work already. Let's understand where the genuine impact assessments need to be done. And then when we need to do them, I mean, my approach actually at the moment, after all these years, is to say, right, let's get in a room and have a chat. Let's not even start to fill in anything. Let's just sit down and talk about people, as in, what are you looking to do? What are you looking to achieve? Whose data is going to be involved? And let's start to talk about harm and benefit before we fill in anything really, and just have a workshop, even if it's for an hour, just to sit together and talk about it. That's been my approach recently.
So you've mentioned the screening questions, and I know when I used to work for charities, I will always say to people, the screening questions, there were 8 of them, took them 2 minutes. They could literally just run down and say yes, no, or maybe, and the maybes were perhaps the ones you had to have a bit further discussion on.
Yeah.
But would you recommend then, if people have a screening question list, that they actually keep those screening questions as evidence that they've considered the risks involved?
Yeah, I think having that log, if you can get a log together that shows, questions were answered and the outcome was, X or Y, because A, it means that, you can back up why you did or did not go into a full impact assessment, and B, it puts a bit of emphasis on the business area to think about it. This is the other thing that often is the issue with DPIAs. They're seen as something that the DPO's just got to rubber stamp and sign off, which is not what it's about.
And that leads me to a point I was going to raise, because to some organisations, especially if they're really small charities, this is going to sound like a really scary process. So do you have to be a qualified person in data protection to actually complete one? You've mentioned having a sit down and a discussion. How does the lead, sorry, my glass is going wonky there. Who generates the lead on these sort of things?
Well, this is the thing that actually, again, a misconception is that it's the DPO, some qualified data protection genius, who's got to take in all this information and understand it and, judge whether they can go ahead and do this thing. And that's not what it's about. The DPO's obligation, when you look at their role, is to actually advise and maybe guide the direction of the impact assessment. The DPO's advice may be ignored. The business may say, given the assessment, thanks for flagging the risks, it's that critical to our success, we're going to proceed anyway, thanks. And that can be a genuine outcome from an impact assessment in theory.
Yeah, I totally agree. I mean, I can remember working with an organisation, a charity, who were talking about one of my favourite perennials again is the Facebook tracking pixel. So if you're going to have a Facebook tracking pixel on your charity website, have you considered, because obviously when a lot of charities use Facebook to help generate engagement, increase traction and get people to donate to the charity. But is that Facebook tracking pixel also going to be on pages that your beneficiaries or service users are going to be visiting? And is there a risk if they're deemed to be vulnerable beneficiaries or service users, what impact could it have on them? So would you, for things like the technology and cookies, would you recommend DPIAs being used in that context?
Yeah, I mean, certainly to understand the detail. I mean, you know, I've been looking like you, Bev, looking at it for many, many years, and it's still confusing enough to me because Google and Meta keep shifting the ground, and maybe I'm being facetious, keep developing their products to improve how efficient and effective they are, or switching legal terms or changing their contracts, or, you know, it's a dynamic area. So certainly having a space to thrash that out internally and talk about it is very beneficial. But again, understanding that if we're just tweaking something that's already up and running, you probably don't need to stand back and do a full-on assessment. However, if we're, like you said, Bev, dramatically changing where we're going to deploy these pixels and what that might mean for people, yeah, then you might stand back and say, is this right for us? Do we want to go down that route given what we're trying to achieve and the impact it might have on people? Yeah.
And do you think the expectation in the charity sector is going to be different to that in a commercial sector? If you're, you know, I talk about, I have this ethos that I've always said, you know, if you've got in your values and behaviours, you'll treat your service users and your supporters with dignity and respect. My view, and this is my personal view, is that you treat their data with that same dignity and respect. So do you believe in terms of DPIAs that there's a different expectation for people who are engaging with the charity sector to that of a more commercial organisation?
It's interesting, isn't it? I mean, in one way, this is the issue with charities, that they're probably held up to a higher level by the public, maybe. So there's a different sense of what they will or won't do to achieve their objectives. Whether that's right or wrong is a different issue. There's often a disconnect between those two. That's the issue, is that people don't necessarily realise that some of these charities are quite large corporate bodies and therefore act like that. So, but certainly the impact assessment is an opportunity to bring that into the table, to bring to the table, look, hang on, are we contradicting ourselves here slightly, given what our stated position is? If we look at the potential impact on people, going back to the people point, and because the bit that again is often missed, or we're going to get geeky now, sorry, but recital 75 of the GDPR, you know, the recitals are very useful. They're the guide to the GDPR that, you know, you can actually use to get a sense of what were they thinking of when they wrote that bit of the GDPR. And when it says about risk to the rights and freedoms of people, it says, well, look, you should be thinking about a mixture of different harms that could occur. And the way it describes it is the physical, material, or non-material damage. And that's why I really like that, because if you start to talk about those sort of things with your colleagues, they can kind of grasp that. You can say, okay, could what we're doing lead to physical harm, someone being attacked, someone being pursued physically in the real world?
I hope you can't hear. Sorry, my tummy is rumbling. I hope you can't hear.
No. No, we couldn't.
It proves it's live and real, doesn't it?
There you go. Yeah. But yeah. Sorry. What was I saying? Oh yes, yeah. But talking about physical, material, and non-material harms. I mean, once you just get those topics themselves don't sound maybe engaging. Once you describe what they are, physical harm, material harm, financial loss. Could what we're doing lead to identity theft, financial loss for someone? Or non-material damage? Could it lead to, depriving people of their rights, reducing their ability to control what happens with their data? Could it lead to discrimination? Could it lead to damage to reputation? These are tangible things that people can get their head around a bit and go, well, okay, what we're planning to do is X. Yeah, could it lead to physical, material, non-material harms? And then you say, well, okay. People then often switch off because they go, yeah, it could, but it's so unlikely. So they just think, oh, well, the risk is 0 or low. And you need to tease that out as well. I don't like using, the typical thing when assessing risk is having a grid that's got 2 axes and you've got impact and likelihood, and you can fiddle the numbers as much as you like. Let's be honest. If you don't want it to go red, you don't make it go red. It's kind of, I mean, you know, does it achieve the objective? No, because you can fiddle the numbers and make it say one thing or another. What's actually the way I go about it is to say, well, let's think about what harm might occur, and then let's see, well, there's three things that need to be in place for that harm to occur. You need an instigator. You need someone to make this thing happen, or have a desire to want to make this thing happen. That instigator needs the opportunity to make that thing happen. And is there any friction stopping them? And then it's like Swiss cheese. If all three line up, where you have an instigator who has some opportunity and there's not much stopping them, well, then that harm could happen. And that model I've found really useful over the years, because it takes away this whole, you know, impact versus, you know, a grid thing where you can fiddle the numbers. It stops people going, yeah, but that's unlikely, and they just switch off. Actually, you get colleagues thinking about, oh, okay, yeah, we don't need to pay much attention to that one, but that one, yeah, there's something there that could actually lead to that sort of harm. What are we going to do about it? Do we accept that? That's just the price of doing business. Could we change the project? Could we tweak our supplier? Could we reduce the volume of data? What mitigation might we do to try and draw that thing down?
I think you raised some really good points there, Gary, especially, you know, I know I bang on about cookies and tracking pixels and everything, but if you think about the audiences that visit your website, the risk of harm, is going to be completely different, say, supporters than it is to if you've got vulnerable service users. So you have to not just think about people, but what type of person it is.
Yeah, no, exactly. And
The time is
oh yeah, time's flying along, isn't it? So we
the
could
time
talk
is
about this for all day.
flying. I've got one more
Oh, go for it.
question.
Go for it.
But I don't know if Sarah or David have any. So I was just going to raise the flag of any impact from the Data Protection and Digital Information Bill on DPIAs.
Yeah, well, yes, because they're looking to change it, basically. So the government's looking to amend, update, refresh the DPIA section of the UK GDPR. And it's interesting because a lot of what's planned and the changes that are planned, you know, I think a lot of the data protection community aren't particularly enamored by, or can't see necessarily the point of a lot of it. But actually, I think what they're trying to do here is almost what we've just been talking about, trying to get people away from being so prescriptive in saying, well, look, it has to do this, this, and this in this order, and making people realize it's about assessing risk. It's about being grown up as an organization. It's about coming up with a method that works for you and your staff so they actually engage with it, and using it as a proper tool to manage data risk for new projects and big changes. And I think that's what it's trying. I mean, I've read it a number of times, and you can read it as watering down so people don't do so many of them, but also giving them the flexibility to come up with a proper method that works for them without being so prescriptive or following templates that don't really work. So I think if it's embraced well, the changes could be beneficial. Could be.
I think the only thing you have to factor in is where organisations might be working in the EU as well are going to suddenly find themselves facing two different sets of legislation, and you need to comply with both.
Yeah, true. But again, you would think and hope that like a lot of these things, if you're an organisation that's trying to do the right thing already, then you're still going to try and do the right thing when the government tweaks the legislation. If you're already looking to just rubber stamp things by the DPO to do what you're doing anyway, well, then you're going to lean into the other way of looking at the government's changes and probably do slightly less, but you weren't really engaging anyway. So, it's not going to make much difference either.
Yeah, I agree. So we're rapidly running out of time. David or Sarah, did you have any questions at all? You don't have to have any.
I have a quick question. Just so if I work for a small local charity, and we don't there's been a lot of staff changes, and I don't think we have a lot of sort of DPIAs or anything in place. Would you recommend that we start with looking at our higher risk activities, or should I be looking to just do some sort of background work on the lower risk things that we're just doing every day without really thinking about it.
I think it's that. So I'm almost what you're saying is, and I get asked this a lot, is it like worth doing a retrospective DPIA?
Yeah.
And that's kind of a oxymoron, really, because you know,
yeah,
you're going to actually stop doing the processing if you did conclude it was really damaging to people. Then there's not really much point in doing an impact assessment. However, there is a strong point in checking the compliance of what you're doing at the moment. So you're right.
Mm-hmm.
I certainly look at it and say, if we've got some high risk things or some interesting activities, let's just check that they're being done well. You know, have they got privacy information? Is the security appropriate? If we're using a supplier, is there a contract in place? These are, you know, bread and butter data protection compliance things. Definitely look at them, but don't try and dress it up as a retrospective impact assessment, because it's not.
Yeah.
Establish going forward the screening questions and the future things. Yeah, definitely. Yeah.
Thank you.
Thank you, Sarah. That's an interesting one. Well, that's just about wrapping it up for today. We've got another webinar in a few weeks' time. I think it's 4 weeks. It's on the 21st of March. That one is going to be myself and Mike Roberts from Making Digital Real, and we're going to be looking at email security, because how many people have never sent an email to the wrong person in their career? I'm sure nobody can put their hand up. So thank you both for attending. I'm sorry the others, should have been 4 other people on the call, so I don't know what's happened, but hey, you know, it's half term and people get caught up in other things. So thank you so much for joining us. This was our very first one that we've run. If you do have any feedback and want to drop me an email or anything, be really grateful. Just from your perspective, was it what you thought it was going to be? Did it answer your questions? Was it informative, right pitch, right tone? Just so we can get the rest right. But say that there's a whole series of them now that are available if you want to join us. So thank you ever so much both for coming.
Thank you
very much.
Thanks a lot.
Bye.